Hello, everyone. This is Alex Barthet, along with the folks at SunRay Construction Solutions. Today, we're going to be talking about how to deal with your notice to owner if you missed it. What happens? Do you still have lien rights? And how do you protect yourself? So as we get into this webinar, you will see the GoToWebinar chat box, which is on your screen. If you have any questions, go ahead and use the chat box. We will answer all the questions at the end. Rachel will read them to us, and I will answer them. Please do not include the names of any companies or people in your, do not include the names of any people or companies in these questions. All right, so what are we going to talk about today? We're going to go over the basic notice to owner and lien rules. You need to understand what those rules are in order to understand where you can make the mistake. We'll talk about the fact that maybe you only thought you missed a deadline and there was no deadline to begin with. There are a lot of exceptions in the lien law, and sometimes you think you have a deadline and you actually don't. On jobs that have bonds, we're going to talk about other bonds that exist on the project that may be able to be a recovery source for you. We'll talk about suing for breach of contract, suing for unjust enrichment, other legal theories that you can pursue in case you miss your lien or bond deadlines. And of course, we will answer any questions at the end. So let's get into it. What are the basic notice to owner and lien rules? Okay, you need to serve a notice to owner within 45 days of your first work or delivery of materials to the job site. You need to record your lien, or on a job that has a bond, you need to serve a notice of non-payment no later than 90 days from your last work or delivery of materials to the site. And then you also need to file a lawsuit to foreclose on the lien. That is a legal action. You have to hire a lawyer, file the legal action within 1 year of the recording date of the claim of lien. And if the job is bonded, you need to file a lawsuit within 1 year of your last work on the job. So a bond claim is shorter to sue on than a lien claim. So remember that distinction of the timelines associated with lien claims and bond claims. Now, there are lots of exceptions to the rules that I just told you, and we're going to go through some of them so you understand why maybe you actually did not miss a deadline that you thought existed. So let's talk about when you don't need a notice to owner. You do not need to serve a notice to owner when you have a direct contract with the owner. So for example, if you are a supplier that delivers plumbing materials to a job and the party that hired you to deliver those materials to them is the owner, you do not need to send a notice to owner. Where we see this as people getting confused is when they typically are a subcontractor, for example, so maybe they're a plumber, and occasionally they get hired by an owner. Well, when you're hired by an owner, you have a direct contract with the owner, therefore you don't need to send a notice to owner. I still recommend that you do. Our advice is you should send a notice to owner on any job that exceeds a monetary threshold you set in your office. $500, $2,500, $10,000, pick a number and just know that any job over that amount, you're going to notice. Then you don't have to worry about whether or not you did or you didn't send a notice, or whether you needed to or didn't need to send a notice. Okay, the next one. No notice to owner is needed when you are a subcontractor and the GC and owner share a common identity. Let me explain what I mean. If I am a developer and I develop property, but I have an in-house general contractor, right? So effectively a captive GC that works for me. If you are the plumber on that job, you don't need to send a notice to owner in order to have lien rights on my property. And what the reason is that the law is going to combine the owner and the GC entity. They're going to collapse them and make them one. And the reason that they're going to do that is because in many instances, they share the same officers, they share the same address. And if the purpose of the notice to owner is to make the owner aware that you exist on the job, therefore you have lien rights, well, if the owner and the GC are effectively the same, then you don't need to serve a notice to owner because the owner, through its GC, knows you're there. Again, there are certain developers in various parts of Florida that have an in-house captive GC. That's when this applies. No notice to owner is needed. Again, in this case, because we're talking about bonds, it's technically called a notice to contractor. So that's not needed when you have a direct contract with a bonded contractor. So, if you are the electrician on a project and the general contractor has a bond on the job, you do not need to send that notice to owner, notice to contractor. Again, the idea of the notice to owner or on a bonded job, notice to contractor, is to make sure that they know you exist. Well, the claim on a bond goes through the contractor. So if the contractor signs a contract with you, you don't need to send them a notice to owner, notice to contractor, because they know you exist. Another common deadline we see people think exists that actually doesn't exist is the notice of non-payment when you have a direct contract with a bonded contractor on a public project. Let me say that again. If you are the roofer on a public job, right? So let's say a school board project, you're putting a new roof on a school, on a public school. The GC has a payment bond. You obviously don't need to send that first notice, the notice to owner, notice to contractor. We just talked about that. But you also don't need to send a notice of non-payment. That's the notice that comes out 90 days, no later than 90 days from your last work. Now, on a private job that's bonded, you still need to send the notice of non-payment. But on a public job, you don't need to send the notice to owner, the notice of non-payment. The only thing you have to do to secure your rights on a public job where you have a contract with a bonded contractor is to sue the surety within 1 year of your last work or delivery of materials. Another thing to keep in mind, again, we're talking about ways to deal with the fact that maybe you think you missed a deadline, is that on a bonded project, the 45-day notice to owner, notice to contractor deadline does not start to run. It does not even begin to run until you have actual or constructive notice that the job is bonded. What does that mean? That means that the bonded contractor is obligated to ensure that the notice, that the bond is recorded with the notice of commencement. It's posted at the job site so that when you prepare your notice to owner, notice to contractor, you know that the job is bonded. So I'll give you a very specific example of what happened to a client of ours and how we helped them. They were the mason to a shell subcontractor on a bonded public project. Okay, so they were a subcontractor. Internally in their office, they made a mistake. They thought they sent the notice to contractor, a required document, by the way, in normal situations, but they forgot. When the client came to me, he was owed $100,000, and it turns out that, by the way, this is now a few months after they finished their work on the job. It turns out that the subcontractor filed for bankruptcy, right? So the person that hired them filed for bankruptcy. They didn't send that notice to contractor within 45 days of their first work. So when he came to me, he said, Alex, we really screwed up. We probably don't have any rights. It's $100,000. It's a lot of money for us. Is there anything we can do? So we did some research and we determined that the bonded contractor in this case did not record a copy of the bond as the contractor was required. Because the contractor never recorded a copy of the bond, the 45 days never started to run. So we did some more research and we found what was the bonding company for that project. We sent the notice to owner, notice to contractor. Again, remember, the client started the job over a year ago, finished the job 2 months ago. So well after all of the deadlines you would expect. We served the notice to contractor. We then the next day served the notice of non-payment. The next day we file our lawsuit. Fast forward about 4 months, we convinced the judge that they failed to comply with their obligation to record a copy of the bond, and we were awarded all of our fees, the underlying $100,000 principal, fees, costs, and interest, right? So that is one mistake that when the client came to us thought, you know, I'm screwed, there's nothing I'm gonna be able to do here. And because the contractor made a mistake and there were exceptions in the lien law, we were able to get him paid. So the moral of the story, even if you think you don't have any rights, you may actually have some rights and it's worth investigating. Now, the lien law is very complicated. We have a desk tool, it's called the Lien-O-Matic. Sits on your desk, it has the answers to most lien questions right in it. It's very easy to use. You can get it completely free. We've sent out about 8,000 of these so far since we made it. Go to lienomatic.com, fill in your information, and we will send you one completely for free. It'll take a few days to get it in the mail, but we're happy to send it to you. All right, another thing to look at is there another bond that you can go after? Everyone always talks about the general contractor's payment bond, but maybe there's another bond. Maybe the subcontractor on the job, the electrician, the plumber, the roofer, maybe they had to post a payment bond. And if they did, and you were a material supplier to the subcontractor or a subcontractor, you would have rights against that subcontractor's payment bond. Now, the problem is you don't even know that it exists. It's not recorded in the public record. No one's given you a copy of it. So how do you get it? How do you get your hands on it? So you want to send a request to the contractor for a copy, to your customer, the subcontractor who may have posted a bond. You want to get them to ask them for a copy. And you want to make sure that in your request that it goes in writing. Ideally, it goes certified mail. I would start with an email. Maybe the contractor will give it to you. But if you don't get it and you think it exists, you'd send a certified letter requesting a copy of the subcontractor's payment bond on the project. Once you get it, the question is, what do you do? Like, how do you make a claim on this subcontractor's bond? The short answer is every bond is different. It's just like a contract. So as a result, you need to make a claim on that bond based on what it tells you to do to make a claim on the bond. So you have to physically get the bond, you have to read the bond, and then you have to do whatever the bond says. So some bonds say that if you want to make a claim, you have to send the bonding company this list of information. Other bonds say, you know, you don't have to send us anything, and if you sue us, we'll deem the lawsuit the claim. So to make a claim on a subcontractor's bond, you got to physically get your hands on it, and then you have to do what it says. All right, so we talked about exceptions to the lien law where maybe you didn't lose rights. Maybe there's an exception where you didn't need to send a notice to owner or a notice of non-payment. We talked about sub bonds as a way to maybe get paid. Let's talk about some other legal theories on ways to get paid. So one is obviously to sue someone that you have a contract with for breach of contract. So a contract obviously is an agreement between you and another person or entity. Ideally, it's signed. It doesn't have to be signed. It doesn't have to be a formal agreement. It can be a handshake. It could be invoices or proposals that are ideally signed, but again, they don't have to be. It just has to be an agreement between parties that something is going to be done in exchange for some amount of money. Now, you have to be very careful with pay when paid. Someone can hand you their contract and it can say, I am only going to have to pay you if I've been paid. And in those instances, you may not be able to sue for breach of contract. Now, there are exceptions to the pay when paid rules here in Florida. So you may think it's a pay when paid provision, but it may not be. I had a client come who's a roofer. He's owed $250,000 for a roof that he did. He was a roofing subcontractor. He signed the contractor's contract, and it was like 25 pages. I just assumed that it had a pay when paid provision in it. And when we read it, it did not. It had a provision that looked like a pay when paid, but the law is very specific on what a pay when paid provision has to say. It has to have certain magic words. Well, it didn't have those magic words, so now we're proceeding with a claim against the contractor in addition to asserting a lien on the property. So let's talk about how to sue for unjust enrichment. Unjust enrichment is another legal theory you can pursue. Unjust enrichment is very simple. You have not been paid. That's the unjust part, because it's not fair that you did work and didn't get paid. And you conferred some benefit to the other party. That's the enrichment part, right? They've been enriched and you haven't been paid, and that is unjust. Now, typically we use this as a claim, as a backup claim, even when we sue for breach of contract or lien foreclosure, but we also use it as a means to bring claims further up the chain of contract. So for example, if you are a supplier to a subcontractor and your materials got to the site, one of the claims you could make is a claim against the owner for unjust enrichment, because if your materials made it to the job site, they benefited from it, they were enriched, and if you haven't been paid, that is unjust. Now, the single biggest defense we have to deal with for unjust enrichment claims is the fact that whoever you're bringing the claim against actually paid value to the person they hired, and therefore no claim exists. So let's go back to my example of you being a supplier for materials to a subcontractor and you sue the owner for unjust enrichment. Well, if it turns out that the owner paid the contractor everything that the contractor was due, even if the money didn't get all the way to you, well, guess what? They're not, they haven't been unjustly enriched, right? They paid somebody. The problem is it didn't get to you, but they didn't benefit without having paid compensation. So if the owner paid the value to the contractor and it didn't make it to you, that will defeat the unjust enrichment claim. So let's recap. You need to know the basic notice and lien rules. You need to exhaust all available exceptions in the lien law. And again, if you go to lienomatic.com, we will send you the Lien-O-Matic. You can keep it on your desk. So if you have questions about how to, what exceptions apply, what's the time frame for private projects, Miller Act, FDOT, federal jobs, all of those are listed in this Lien-O-Matic tool. Next, you want to see if you are a sub or a material supplier to a sub. Did the subcontractor post a bond? If so, maybe you can make a claim there. Can you sue for breach of contract? And can you sue for unjust enrichment? We have one other tool. It's called the Lien. It's also a handy desk tool to help you calculate the 45 days for your notice to owner and the 90 days for your claim of lien and notice of non-payment. We can send it to you for free. If you go to calculien.com, put in your information, we'll stick it in the mail and you'll get it in a few days. So with that, Rachel, we are all done. Does anybody have any questions?
First of all, thank you so much, Alex. It was a wonderful way. As always, you provided some really great information for us. As for the questions, yes, we do have a couple of questions here. So for the first one, can a lien still be valid if the contract wasn't in writing?
Yes, you do not need a written agreement to have a valid lien. So if I'm the subcontractor on a job and the contractor hires me and we shake hands and I do the work and I'm not paid, as long as I follow the lien law rules, which we went over, notice to owner, claim of lien, file suit within a year. As long as all of those rules are followed, the contract does not need to be in writing to have lien rights.
Okay, second question. If a bond was never recorded, does that change or extend the deadline? Also, if a notice of commencement is recorded late, does that affect the deadline in the same way?
Okay, those are two different questions, so let's break them apart. If the bond was never recorded, does it extend the deadlines? The answer is yes. That was the example that I gave of the mason that never sent a notice to owner, notice to contractor, only to find out that the bond was never recorded in the public record. So yes, the deadlines are extended to the extent that you needed to send a notice to owner or notice of non-payment, that you couldn't do those things because you didn't know that the job was even bonded. The one deadline that will not move, even if the bond is not recorded, is that you still have to file a lawsuit no later than 1 year from your last work. So if there are other deadlines like the notices that you missed, that's fine, but you're never going to be able to move 1 year from last work deadline.
Okay, next question.
Oh wait, there was another question about the notice of commencement, right, Rachel?
Okay, it says, also if a notice of commencement is recorded late, does that affect the deadline in the same way?
No, the short answer is no. All of the deadlines we talked about are irrespective of the recording of a notice of commencement. The only difference may be that if the notice of commencement listed people that needed to get a copy of the notice to owner, but you started your work and therefore you sent your notice to owner already and they didn't get a copy, you're okay. Meaning they can't invalidate your notice to owner because they say, well, you didn't send it to the person I listed in my notice of commencement. Your response would be, well, you started construction before you recorded your notice of commencement. I wouldn't have known you existed because you didn't record your notice of commencement on time. But all the deadlines remain the same. Okay,
next question. We are a roofer contracted with the GC for a residential roof, no bond. Homeowner is suing the GC and we are still owed $22,000. The GC is saying he cannot pay him until him and the homeowner resolve by mediation. Do we have any recourse with the GC? Job has been completed for 8 months.
So question number one, does the contract between you and the GC have a pay when paid provision in it? The fact that he can't pay may mean that he doesn't want to pay, or it may mean that he financially can't pay. The legal question is he obligated to pay whether or not he's been paid by the owner? So step one, you have to look at your agreement between you and the
update, no pay provision.
Well, then you can sue them. Yeah, you can make the claim against the contractor and say, I am sorry you haven't been paid. You still have to pay me. And if he doesn't pay you, then you can sue him in court to be paid for the money that you're owed. Whether he has the money or not, I don't know the answer to that. But it sounds like you have every legal right to be paid for the work you did.
Okay, one more question here. The property is about to be sold to a new owner, but I still haven't been paid for my work. I'm concerned the new owner will end up benefiting from the improvements while the previous owner avoids paying. What options do I have?
So, assuming that there is a notice of commencement that has been recorded for the work that is done, that is going to create a title issue for the new buyer. Meaning when they close on the property, that notice of commencement is going to be out there and it needs to be closed for them to get title insurance. That being said, if you're that concerned, you should record a lien, right? Because if you record a lien, that is definitely going to throw a wrench into the works of any closing that's happening. So
right.
If you're concerned about getting paid, I would record a lien.
Okay, perfect. that's all the questions we have. So if anyone does think of a question that wasn't addressed after this webinar, just please feel free to reach out and we'll be sure to answer any of your questions. The next webinar is Thursday, April 16th at 10 a.m. and that is titled Stop, Don't Sign That Release Unless It Says This. And then after that webinar, the next one will be Thursday, June 18th at 10 a.m. And that one will be about 7 common lien and release traps and how to avoid them. So go ahead and register for free at sunraynotice.com/education. And then if you could go to the next one. Okay, so let's talk about our upcoming live seminar. If anyone's going to be in the Palm Beach area, Alex is presenting alongside with Ariella for a live seminar on May 21st. And this will be about the lien law and waiver and release masterclass combo. So if you're interested, please register at sunraynotice.com/seminar. It's going to be an incredible event packed filled with tips and tricks for you guys. Okay, and then if you would please just take a moment to review us on Google, we would really appreciate that. It takes about 1 minute of your time, but it really does help our other contractors like yourselves to hear about us. Okay, and that's all that we have for you guys today. Thank you so much for everyone that attended. We hope to see you at our next webinar. And Alex, thank you again. You are fabulous. I hope everyone has a sunny day.